Welcome to Law and Crime. Aaron Keller here along with Janine Atamian. We're going to watch the Kellen Winslow case as the evening rolls along. The jury is hearing a readback after asking this question of the judge, saying we need to hear the testimony of Jane Doe number 4 as well as the testimony from a friend. And they also said, we're missing an exhibit. You need to make sure we have that. Again, Jane Doe number 4 is the youngest accuser who said that an attack happened on her many years ago, back when she was 17 years old. And this accusation came forward all these years later because Jane Doe number 4 said, I saw the coverage of this defendant, Kellen Winslow II, being arrested on all these other charges, and I need to jump in and tell prosecutors what allegedly happened to me back in 2003. That's how this charge came to the forefront. The question is the accusation credible? And the defense attacked not only Jane Doe number 4, but all of the other accusers. Jurors are listening to a readback of that testimony. As we saw, I think we're going to dip in and listen to a little bit of that and see exactly where they stand. To a readback along with jurors in the case against Kellen Winslow II in California. He, of course, is the former NFL player accused of a series of sex crimes involving 5 women. Jurors asked earlier today to hear the testimony of Jane Doe number 4, the youngest of the accusers, who said that she had consensual sex at one point with the defendant, and then a short time later was actually raped by the defendant. Janine Atamian is with me here. She practices law and real estate, as we were just talking. So this is cumbersome for jurors to actually sit and listen to this testimony in this format. A lot of people say, why not just give them the actual transcript so that they can read through it? Why does it have to be a readback?
Well, the court reporter has to read it back because it's part of what they're doing. She's got to read it back so that they can't analyze differently than what was said.
So it has to be a spoken word and not an actual transcript. Now, we see some courts in some states will actually give jurors a transcript of something, but then they get an instruction that the transcript is not the official version of it. It's just an aid to help them follow along.
Exactly.
But still, this gets cumbersome.
It's cumbersome and it's difficult to watch because it's not the same thing as the testimony that they saw earlier, because it's the court reporter reading the question, answering the question. There's no emotion, there's nothing, so it's difficult. It's difficult to follow too. And
then of course there's the flip side, which is sometimes even more infuriating for jurors, is when jurors in some states ask for a readback. They're told flat out, no, you have to rely on your notes or your memories. And so every state seems to do this just a little bit differently. We have the benefit, of course, of actually listening to the testimony of Jane Doe number 4. And sometimes we wish that we could just play things back like this for jurors. You're going to listen to what Jane Doe number 4 had to say on the witness stand for herself. Those are some of the key moments in the testimony of Jane Doe number 4 that we selected here at the Law and Crime Network. But Janine Atamian, we don't know exactly what jurors want to hear here. I have to wonder if what jurors want to hear is exactly what we selected, because look, her account is just horrible. It's horrible to think that something like that may have happened. But at one point there, she backed up and said, I don't know what I said. And the defense was saying, well, you don't seem to remember much. You were drinking. You weren't sure if you blacked out. And those are the sort of things that cast some doubt on the credibility of the accuser.
I think in this day and age, though, no, she can say no at any time. She didn't do anything to warrant what he did. For me, the prosecutor kept saying about how he takes what he wants. The interesting thing about going to her testimony is that's been a pattern with him. He's been taking what he wants from the get-go. So that's why I think they're going for it, just to kind of get back to that and be like, okay, this is what he does.
There's a story in chief, and then there's the way that the defense attacked the story. And the question is, did the defense mount a good enough attack? And you don't think the defense did at all?
No, I think that the defense did a good job at what they were doing. I just don't think that they're going to ultimately be successful. I think that there are 5 different women that don't know each other with very similar stories. There's the evidence with regard to his bike route. There's a lot of stuff. And again, he didn't testify. So I think he was the only person who could really kind of make his case.
He didn't have to, of course.
He didn't have to.
He can sit there and remain silent. But look, a lot of gaps in this case, according to the defense. The state says, no, wait a minute, do exactly what Janine said. Take all of the accounts, add them up, and it results in credible accusations. 2 sides to this case, jury trying to figure it out. That was the prosecution closing argument as to Jane Doe number 4. And you listen to the state basically try to plug any gaps the defense tried to open up in the testimony. Janine Atamian is here with me on the Law and Crime Network. So overall, you believe the state theory as to this particular accuser. You're saying, look, she knows that she said no. She knows that she wanted him to stop. She remembers telling him to stop. Maybe she just doesn't remember the exact words, but no means no.
I absolutely think no means no. And then the other thing, like we were just talking about, and I think that the prosecution missed an opportunity with Jane Doe 1, who was a really bad witness, but they got out there these repugnant statements, these racist statements she made, and the defense is trying to say that she had consensual sex. If she's a racist, is she having consensual sex with a man of color? So to me, I think they missed an opportunity to drill that in during the closing argument.
That might have won that point of that case for the prosecution, but I don't remember the prosecution bringing that up. Maybe they missed it. The issue there that the defense tried to dig into is exactly where this alleged assault, this alleged rape happened. Was it in a car or in a house? Because Janine, apparently, she told that ex-boyfriend it was in a car, and then she said it was in a house. Is that an inconsistency that's too much for the state to override?
Well, here's the thing. The defense also brought that up in opening. And I think it is a problem because she's changing the location. I get that it happened many years ago, but if I were on the jury, I'm thinking that's not something I would forget. So I do think it's a problem for her testimony. But again, collectively with all of the women, I think they can still overcome it.
And that's exactly what the state wanted people to do. And then the defense jumped up and said, wait a minute, no, the state has to prove every element of every charge beyond a reasonable doubt. And it's hard to sit here and with a laser separate every element of every charge from everything else that you've heard in the course of a trial like this. That's really, really hard.
Of course it's hard to do. But again, the prosecution is getting it collectively out there. We were talking about it before. They called the direct witness, then they call everybody to back her up. So to me, I think she does end up coming across as credible. She's feisty on the stand. She doesn't back down. She, asserts herself that this is what happened to me, and she doesn't cave to anything that the defense is saying to her.
So what's interesting here is that the jury asked to hear a readback of the testimony of Jane Doe number 4 and of the friend, Nicole Edwards. They did not ask for a readback of the testimony from the boyfriend. So I wonder if they've already settled this point or whether they didn't. And ultimately, the question is, does this lead to a not guilty for Jane Doe number 4's accusation?
Well, the problem with calling back the friend, and I'd be nervous if I were the prosecution, is the defense got her to say that Jane Doe 4 said, let's take him down. So is it let's take him down because of what he did to me years ago? Or is it let's take him down? Here's a guy we went to school with. He's famous. I see all this on the news. Now I'm going to come back with my story.
There's a couple of different ways to characterize so many things that were said in this case. The jury has a very difficult job in a case such as this. We're going to move along and listen to the way that the defense closed off its case as to Jane Doe number 4. That's how the defense wanted jurors to look at the testimony of accuser number 4. So Janine Atamian, is it a big issue that she basically said she would support the victims regardless of whether they were telling the truth? Well, if they're not telling the truth, then logic would ergo suggest that they weren't victims. Is that a big issue for the state's case?
So he's trying to make it the issue. He's trying to make it the crux of it. However, when I hear that, I think to myself, here's a girl who was raped in high school, didn't say anything, and so this man went on and continued to do this to other people. So when she says I'm going to support the victims, it's because maybe if I came forward, this wouldn't have happened. So he can make his argument, but again, you're going to have a jury that's going to, we're in the Me Too era, they're going to be looking at things differently. Maybe they're going to agree with him, or maybe they're going to take the position that I do, that she's feeling like if I had said something, maybe this wouldn't have happened.
You should have prosecuted this case. I think you're convincing me a little bit more than the state did on this particular situation. Are you a former prosecutor then?
No.
Wow. Okay. So perhaps your defense attorney and you're sitting in the other chair here, handling the prosecution's work. We're going to dip in and listen to some of the live readback right now, though, because the jury, as we've been saying, asked for a readback of the testimony of this Jane Doe number 4, as well as the testimony of the friend, Nicole Edwards. Here's where they are right now, live. That was a live look inside the courtroom in the Kellen Winslow II trial out of California, where jurors, as we speak, are hearing a readback of the testimony of Jane Doe number 4. Janine Atamian is here with me now. So yesterday, jurors asked a question about the health tracking app data that is said by prosecutors to put the defendant past the house of accuser number 3. That was number 3. They wanted more information about that yesterday. Earlier today, they asked about accuser number 4. So logically, some people are wondering, are jurors moving in order? And perhaps they've already settled on situations involving Jane Doe number 1, Jane Doe number 2, Jane Doe number 3. They want to figure out number 4, then move on to number 5. Does that sound logical?
That's what I think is happening.
They're moving step by step.
That's what I think.
So,
I mean, that would be what I would do if I were on that jury, so yes.
Okay, so in other words, is a verdict coming tonight, or is this going to push into another day tomorrow?
I think that you will see a verdict today.
Wow. Okay, so you're making strong predictions today.
I
here.
do.
So this will be interesting. I guess some of it's going to depend how long it takes to do the readback, because we've got, let's see, another hour and a half, almost 2 hours, depending on how late they go. This might take a while, though. I think it might push into another day. Weirdest part of this case is this whole concept of, well, some of this sex was consensual. You know, there's just some things that don't really sound believable. Why is an NFL player running around having consensual sex with people who say they're transient and homeless? Something about that just doesn't ring true, just as a threshold face value statement.
None of it makes sense. I mean, again, this is an NFL player. This is a man with money. Why is he not going to a hotel room? Why is it on the side of the road? Why is it in a field? Why are you climbing over a fence? It's a lot of in the car, in the parking lot. It's very, very strange circumstances. And he's a married man. It just doesn't make a lot of sense. And again, like we talked about with Jane Doe 1, I don't think that a person who has those racial opinions is going to have consensual sex with a person of color. I just don't think so.
Yeah, okay, I agree with that. And, you know, I said at the outset of this case, look, I realize the defense doesn't have to prove anything, but when the defense starts using these as sort of grape shot, scatter shot theories, well, you know, as to number 1, it was consensual. As to this other one, it didn't happen. As to the other one, it was consensual. As to the other one, it was just nothing. It was all exaggerated. When you start kind of like coming up with a theory as to why it didn't happen, you have to worry as a defense attorney, am I losing credibility completely with the jury? Because I'm admitting that my client's out there having sex with random women, basically. And if he's doing that, then maybe the jury's just going to look and say, okay, so it's likely that he did these other things.
Okay, but during the opening argument, he talks about the sex and the consensual sex with the 2 different women. And he says he won't even call them affairs. There were no strings attached. So he kind of gives the idea that that was just kind of some side thing that he was doing. And then he kind of basically paints everybody else as opportunists who, you know, heard about these 2 women that have come forward, about this case that exists, and now they're going to go after him. He talks about the woman in the hot tub that she and her husband saw him on the television at the gym and was like, oh, that's the guy. You know, so he kind of paints them all as people who kind of just jumped on the bandwagon.
Yeah, I understand the theory and everything, but again, is it a theory that makes sense in light of everything adding up? And that's one of the struggles that a lot of people have with this case. We're going to listen now to some live testimony. Again, this is the readback, I should say, the readback of the testimony of Jane Doe number 4. Jurors sent a note asking for this earlier today. They are getting it from the clerk right now. You heard it from the judge right there, taking a 10-minute break in the midst of this lengthy readback of the testimony of Jane Doe number 4 and eventually the testimony of the friend of Jane Doe number 4. This is what jurors asked for during deliberations earlier today, and they started the readback about an hour and 20 minutes ago, so they've been going at it for a while. This will take some time because they're still in the testimony of Jane Doe number 4 and the discussions that number 4 said that she had with some other people. Of course, eventually, the prosecutor called many of those other people. So, Janine, do you think jurors are getting close to what they're looking at here? What might they be looking for in this testimony?
Again, I think it goes back to her credibility and knowing what Nicole had said and having Nicole say that they were going to get him and that kind of stuff. Again, 1 and 2 aren't that great of a witness. You start to get to 4 and she's much more credible. So to me, I think that that's why they're kind of hung up on this, just to kind of see.
Do you think jurors might zone out by the time they get to cross in this? Do you think that that hurts the defense, or do you think that they're looking for something specific here?
I think they're trying to make heads or tails, just like the rest of us, because there's 5 different cases that are totally different. You know, they're not really the same situation, so they're trying to figure out what's going on with all these situations, and this is one that happened so long ago.
So they asked for a piece of evidence as to Jane Doe number 3 yesterday. It may just be that they came to quick conclusions as to number 1, number 2, and then they got stuck in a point with number 3 yesterday. They asked for that. They didn't get it because it turned out that what they wanted didn't really exist. So they couldn't get it. A jury can't ask for evidence to be manufactured on demand. You know, the judge said you've got what you have, and that's all you have. Now they apparently got to JNO number 4 earlier today, and this readback took a lot longer than expected. Probably had to generate the transcript or something like that. But look, my fear is always that when juries start asking for these full-blown readbacks, that something isn't jiving with the state's case, because the state has the burden of proof. And the jury is trying to launch its own investigation, saying, wait a minute, I'm not sure that it's in there. I've got to hear it again to see if it's in there. And when juries do that, wouldn't one reaction just be, look, the state didn't prove its case to me beyond a reasonable doubt because I can't make heads from tails on the first run here, and therefore I have to acquit?
Well, I think if I were the prosecution, that would be what I was scared of right now, because they are asking for a lot of evidence to come back to them. They are asking a bunch of different questions. So if I were the prosecution, I'd be afraid of that. Then again, you could have that one sole juror who's kind of holding out, and the rest of them are like, we'll get the evidence back to you, this is what she said, and that kind of thing. So it could be either way. We're not in the room. We don't know.
Of course, one thing a lot of the judges like to do is they like to just turn around and say, okay, we can do that, but would it help you more if you focus in on something specific so that this readback wouldn't take hours and rather take a couple of minutes? That didn't happen here. Apparently, they're getting everything. We are going to take a break here on Law and Crime and come back with more discussion about where jurors might be going in their review of evidence in this case. That's in a moment.